Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, it's not often that we get really excited about a case out of Hawaii that involves butterfly knives, but that is exactly what we're going to talk about today. Not because of the actual holdings of this case, which are awesome, and we're going to give some kudos to some attorneys who actually deserve some kudos here on this fantastic piece of litigation. But the reasoning of the court, and the court when you consider who it is, where they are, and what they normally do, this all does not bode well if you are advancing, of course, the cause of civilian disarmament. So there is a lot of positive things to take from this case. So let's geek out today. Let's break it all down, and let's talk about how a huge win from Hawaii spells big trouble for gun control. Okay, so the case we're talking about today comes out of the Ninth Circuit, not the most Second Amendment friendly circuit by any imagination. The case is called Teeter v. Lopez. Now, this is a case that was a challenge to the state of Hawaii's ban on butterfly knives. Now, many of you might know what a butterfly knife is. If you don't, look it up. We're not going to geek out on that channel. It's something along the lines of other types of pocket knives, including switchblade knives and things such as that. Hawaii had an absolute ban on even the possession of these items. Now, of course, that ban was upheld by Hawaii and then moved on to the Ninth Circuit. This case was then decided by a 3-judge panel in the Ninth Circuit. So this is not a full en banc panel of the entire Ninth Circuit. This is a 3-judge panel. And let us remember, with the case of Duncan v. Bonta, which was, of course, the challenge to the magazine ban that came out of the state of California, the plaintiff originally prevailed in front of a 3-judge panel, only later to be reversed by a full en banc panel. So we're not out of the woods yet here, okay? But what I really want everyone to pay attention to is how 3 justices in the Ninth Circuit interpret this law under the new analysis as announced last year by the Bruin court, because this is really important, and where we have seen some very politically oriented courts do skirt arounds and creation of new rules, such as in common use for self-defense and things like that. Here, on this particular ruling, we actually see 3 justices that stuck to the actual foundational structure that was announced in Bruin. Now, before we get too far down the road, I do want to give a shout out to a fantastic Second Amendment lawyer in Hawaii, a personal friend of mine, Kevin O'Grady. Kevin represented the Hawaii Firearms Coalition. He and co-counsel out of Arizona filed an amicus brief on this. So, Kevin, congratulations. You share in some of the glory of this victory. The court started its ruling essentially as follows. In Hawaii, it is a misdemeanor knowingly to manufacture, sell, transfer, transport, or possess a butterfly knife, no exceptions. Because the possession of butterfly knives is conduct protected by the plain text of the Second Amendment, and because Hawaii has not demonstrated that its ban on butterfly knives is consistent with this nation's historical tradition of regulating arms, we conclude that Section 134-53A violates plaintiffs' Second Amendment rights. We reverse and remand. And so immediately the court announces that this activity is protected by the Second Amendment, which means the government must then justify the regulation by finding a historical analog. Because the state of Hawaii was incapable of doing so, because none such exist, the court very rightly and justly here ruled that this regulation could not stand constitutional scrutiny. Now, the court also pointed out that, the state of Hawaii had in fact prevailed earlier on a summary judgment motion and had this thing checked out. But you see, they were operating on what is now a very old and bad rule of law, or as the court put it, on cross motions for summary judgment, the district court applied the then binding precedent to conclude that Section 134-53A does not violate the Second Amendment, granted Hawaii's motion, and entered a judgment in its favor. After Bruin was decided, a motions panel ordered supplemental briefing and denied Hawaii's motion to remand. The appeal is now before us. Now, to save you about 20 minutes of your life, if you do decide to geek out on this opinion, you can skip the first 6-7 pages because it all deals with standing, which is basically government's way of saying, hey, pay no attention to the man behind the curtain. Hawaii came up with many arguments to keep the court, or attempt to keep the court, from getting to the merits of the argument, including standing, and also including an argument that knives do not even constitute bearable arms, and therefore what are we even talking about? The court obviously was not persuaded, and they ruled as follows. Although Bruin discussed firearm regulations, that was because the arm at issue in that case was a firearm. We see no reason why the framework would vary by type of arm. And so with the acceptance that a knife, which in fact is a bearable arm, falls under the purview of the Second Amendment, away we go with the new and modern one-step Bruin analysis. And as the court put it, we similarly structure our analysis. First, we examine whether possession of butterfly knives is conduct covered by the plain text of the Second Amendment. Concluding that it is, we then analyze whether Hawaii has demonstrated that its complete prohibition of that conduct is consistent with this nation's historical tradition of regulating arms. And so with that proper analysis, where does the court go? Well, the court goes right here. Hawaii presents two arguments. First, Hawaii argues that only ordinary law-abiding adult citizens are included among the people referenced in the Second Amendment's plain text. From there, it argues that banning weapons associated with criminals, such as in Hawaii's view butterfly knives, would not violate the Second Amendment. This argument fails because Hawaii's ban is not limited to criminals. Indeed, the uncontroverted evidence in the record shows that these plaintiffs are not criminals, so this defense would not resolve their claims. And then, of course, obviously, Hawaii had to go to, of course, one of the more traditional arguments we see out of those advancing civilian disarmament, which is, hey, these firearms are dangerous and unusual. How did the court respond to it? Well, they correctly applied the legal standard as follows. Second, we similarly reject Hawaii's argument that the purported dangerous and unusual nature of butterfly knives means they are not arms, as that term is used in the Second Amendment. Heller itself stated that the relevance of a weapon's dangerous and unusual character lies in the historical tradition of prohibiting the carrying of dangerous and unusual weapons. It did not say that dangerous and unusual weapons are not arms. Thus, whether butterfly knives are dangerous and unusual is a contention as to which Hawaii bears the burden of proof in the second prong of the Bruin analysis. And so, again, putting Hawaii back to task, they said, hey, listen, it's clearly covered by the Second Amendment. That's what the plain text covers. You need to come up with a historical analog. Now, Hawaii, of course, uses many of the same historical analogs that we've talked about in many other videos, including, of course, the restriction on Bowie knives. Now, please be aware that most of these restrictions on Bowie knives were on the carrying of Bowie knives. This, however, is a restriction on the absolute possession of them. As the court pointed out, aside from these conclusory legislative statements, Hawaii has submitted no evidence that butterfly knives are not typically possessed by law-abiding citizens for self-defense. Having rejected Hawaii's arguments to the contrary, we conclude that the possession of butterfly knives is conduct covered by the plain text of the Second Amendment. They picked apart, of course, all of the historical analogs that Hawaii did, talking about how many of them did, in fact, prohibit carrying of these types of weapons in certain places, but no statute cited by the state of Hawaii had an outright absolute ban on the possession of this, and therefore the court, and very justifiably so, ruled that they had not demonstrated any type of historical analog. Despite the fact that these historical analogs do not need to be identical twins, they need to be somewhat similar, Hawaii could not even meet that burden. Now, one of the other arguments that Hawaii proffers here, and it's argued time and time again, it's argued ad nauseum by those advancing civilian disarmament, is that our founding fathers could have never foreseen the types of technological advancements that have occurred in knives, and therefore these clearly would not be protected. And the dangers caused by these new instruments were one that the founding fathers could have never contemplated either, and therefore it does not fall under the purview of the Second Amendment. Many courts, the Ninth Circuit included, has fallen for that argument in the past. That is no longer part of the decision-making matrix. And these justices from the Ninth Circuit got it right when they ruled, when a challenge regulation addresses a general societal problem that persisted since the 18th century, the lack of a distinctly similar historical regulation addressing that problem is relevant evidence that the challenged regulation is inconsistent with the Second Amendment. Likewise, if earlier generations addressed the societal problems but did so through materially different means, that also could be evidence that a modern regulation is unconstitutional. Now, as I mentioned, we're not out of the woods on this case yet. I'm sure the state of Hawaii is going to appeal. This could end up in front of a full en banc panel of the entire Ninth Circuit. I don't know if that would bode particularly well. However, and this is a huge however, if all of the justices on the Ninth Circuit, or any circuit for that matter, just simply applied the case law as written, well, we're all going to reach the same conclusion. Now, the reason this is so important, other than the obvious reasons, is this. We have two huge cases still kicking around in the Ninth Circuit. One is Duncan v. Bonta, California's magazine ban. The other one is Miller v. Bonta, California's assault weapon ban. Let me point out to the folks in Washington State, the folks in Oregon, that those statutes that you have recently passed are almost identical, verbatim, to the ones that previously existed in California. Therefore, these cases, Miller v. Bonta, Duncan v. Bonta, are going to have huge, and I mean huge, ramifications for folks that live in the Ninth Circuit. If, in fact, the Ninth Circuit has actually gotten to a point where they're going to start correctly applying the law, this does not bode well for those who are advancing the cause of civilian disarmament. Okay, the case once again is Teeter v. Lopez. We'll go ahead and put links for it down below so you can geek out on that if you want. We're going to keep our eyes on this because obviously the state of Hawaii is going to crap their pants. They're likely to appeal this, and this is probably not the last we've heard of it. If you have any other questions about this or anything else related to what's left of our Second Amendment rights, now you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is right down there in the description box. In the meantime, I do want all of you to remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.